Just read it so that we know we're speaking from the same page. Because when you discuss things in chambers, somebody says, aye, he said this. No, he didn't say that, he said this. And 342A, which addresses problems concerning the timeous facilitation and completion of a trial, is governed by that section.
Yes. My Lord, the section reads as follows. The heading is Unreasonable Delays in Trials. Section 342A in brackets 1. A court before which criminal proceedings are pending shall investigate any delay in the completion of proceedings which appears to the court to be unreasonable and which could cause substantial prejudice to the prosecution, the accused, or his or her legal advisor, the state, or a witness. Then subsection 2, in considering the question whether any delay is unreasonable, the court shall consider the following factors. A, the duration of the delay. B, the reasons advanced for the delay. C, whether any person can be blamed for the delay. D, the effect of the delay on the personal circumstances of the accused and witnesses. E, the seriousness, extent, or complexity of the charge or charges. F, actual or potential prejudice caused to the state or the defense by the delay, including a weakening of the quality of evidence, the possible death or disappearance or non-availability of witnesses, the loss of evidence, problems regarding the gathering of evidence and considerations of costs. G, the effect of the delay on the administration of justice. H, the adverse effect on the interests of the public or the victims in the event of the prosecution being stopped or discontinued. I, any other factor which, in the opinion of the court, ought to be taken into account. Then subsection 3, if the court finds that the completion of the proceedings is being delayed unreasonably, the court may issue any such order as it deems fit in order to eliminate the delay and any prejudice arising from it, or to prevent further delay or prejudice, including an order. A, refusing further postponement of the proceedings. B, granting a postponement subject to any such conditions as the court may determine. C, where the accused has not yet pleaded to the charge, that the case be struck off the roll and the prosecution not be resumed or instituted de novo without the written instruction of the Attorney General or the Director of Public Prosecutions now. D, where the accused has pleaded to the charge and the state or the defense, as the case may be, is unable to proceed with the case or refuses to do so, that the proceedings be continued and disposed of as if the case for the prosecution or defense, as the case may be, has been closed. E, that Roman figure 1, that the state shall pay the accused concerned the wasted costs incurred by the accused as a result of an unreasonable delay caused by an officer employed by the state. Roman figure 2, the accused or his or her legal advisor, as the case may be, shall pay the state the wasted costs incurred by the state as a result of an unreasonable delay caused by the accused or his or her legal advisor, as the case may be, or subparagraph F, that the matter be referred to the appropriate authority for an administrative investigation and possibly disciplinary action against any person responsible for the delay, subsection 4A, an order contemplated in subsection 3A, where the accused has pleaded to the charge, and an order contemplated in subsection 3D shall not be issued unless exceptional circumstances exist and all other attempts to speed up the process have failed, and the defense or the state, as the case may be, has given notice beforehand that it intends to apply for such an order. B, the Attorney General or Director of Public Prosecutions and the accused may appeal against an order contemplated in subsection 3D and the provisions of section 310A and 316 in respect of an application or appeal referred to in that section by an accused shall apply mutatis mutandis with reference to a case in which the Director of Public Prosecution appeals, and in the case of an appeal by the accused, the provisions of section 309 and 316 shall apply mutatis mutandis. Subsection 5, where the court has made an order contemplated in subsection 3E, A, the cost shall be taxed according to the scale of the court deems fit. B, the order shall have the effect of a civil judgment of that court. Subsection 6, if on notice of motion it appears to a superior court that the institution or continuance of criminal proceedings is being delayed unreasonably in a lower court, which I don't think is applicable here.
That's fine.
Yes.
I think that's
Yes.
okay. The main sections which
Yes.
this exigency dictates I must address are the fact that in terms of the Constitution, before you interpret, let me just finish,
Yes.
so that it makes sense. In terms of the Constitution, accused persons are entitled to a speedy trial. This section speaks about unreasonable delays, and these can apply to the state, the defense, even to witnesses. Now here we have an expert, ballistic expert, witness expert, ballistic expert, who gives evidence in August, and this is forensic evidence. And then it takes 8 months to cross-examine him, but I don't even know it's going to happen this year. It's unfair on that witness because he's seized with other matters. But the unfairness is predicated on the fact that in the pursuit of the other evidence in this trial, the cross-examination also impinges upon the evidence of this witness who has given evidence in August, and he's not being cross-examined on that. So that percolates to the unfairness of the process, because you can't say, for instance, ballistic expert Mgomezulu put it to Manganyi this and that, and Manganyi said this, and this answer is taken up by Ramosepidi, for instance, that it's a contradiction. You can see, you don't have to be a lawyer. 8 months, no cross-examination. And then in the meantime, we are proceeding with the other evidence, okay? So this impinges on the freedom of the constitutional right of a client like the accused here to have a speedy trial. And if there is a bottleneck, which is precipitated by either the defense itself or the legal aid board in not assisting in the payment of the costs of the ballistic report, which the defense say is important for their proper defense of the accused, then this court is obliged to investigate. It doesn't have to be a formal investigation if you read that. Now, if the legal aid board say we must talk about this in chambers, it is against the law. My recitation is I won't do anything which is against the law. So Mr. Mujuta, when he comes, if the blockage or the delay is predicated, I don't want to say the negligence, on the administrative capacity of his department, he must say it in open court. Because if you read that section 342A, it also involves the public interest and the interest of justice. Okay. So we're going to interpret them for it.
Sizokhumbula ukuthi izolo bekunodaba olumayela nokukhokhelwa kwengoti enifisa ukuthi nimbize azomlekelelake kubona ubufakazi obuthulwa uyena uKenneth Mangena. Kushiwo-ke izolo ukuthi kunodaba la illegal aid ingekaphendulike khona mayelana ney'ndleko abameli kanye nani ifisa ukuthi legal aid inganisiza ukuthi kukhokhelwe yena leyo ngoti aze enkantolo. Umshushisi-ke usetshele enkantolo ukuthi-ke bashilo ukuthi bazoba khona-ke namhlanje, kodwa-ke ngo-11:15, kodwa-ke benesicelo sokuthi-ke bahambe-ke bona nabameli kanye nomahluleli baye kulona ihhovisi lakhe umahluleli ukuthi lelo daba lelo liyodingidela noma liyokhulunyelwa ihhovisi kamehluleli. Usecela-ke umshushisi ukuthi akafundeke ukuthi-ke usection 342A uthini-ke la kufanele khona-ke into inkantolo efisa ukuthi-ke iphenye noma ibe nolwazi ngayo, kufanele lokho kwenzeke la enkantolo umuntu azoma khona kule ndawo engimi kuyona, inkantolo ibese imibuza-ke imibuzo. Manje-ke inkantolo izofuna-ke ukuthi ikwenzeke lokho, ngoba lokho kufanele ukuthi kwenziwe ngaphambi kwenu nikhona nizwa ukuthi-ke la kuzotholakala khona ekugcineni ukuthi-ke ubani noma yiliphi uhlangothi ekuyilona olubangela noma oluyisizathu sokuthi-ke icala leli lihambe ngonyawo lonwabu. Lokho-ke inkantolo ithi kuyinto ekufanele ukuthi yenziwe la enkantolo kodwa ingayokwenzelwa ehhovisi.
Okay. Thanks. We'll await the delegation at 11:15, as it says.
Sizolindela bona-ke nanjengoba besho ukuthi bazofika ngo-11:15.
Yes, Mr. Louis?
I can just add it.
Yeah.
In the email, Mr. Mjito mentions that he'll send someone senior from his office. He himself is not available.
Oh, it's not available. Okay, fine.
God pleases my Lord, this